prepared appeal in the matter of Cutrale Jr., represented by Mrs. Rosana Falcioni and another, and Sanches and others.
Mr. Chichoy.
May I recap briefly my position on prejudice before I move on to the next topic? The inquiry is into whether there is a reasonably arguable limitation defence which would be prejudiced by relation back. The starting point for what the arguable limitation defence is has to be the defendant's own pleaded defence. We accept that is not necessarily the end of the road, but there must be a plausible evidential basis for supposing that there may be a reasonably arguable limitation defence other than that advanced by the defendant himself. Such a plausible evidential basis may be derived from the claimant's case, or alternatively, it may potentially come from evidence before the court. Mere speculation, however, without a plausible evidential basis cannot be sufficient. And that is because the limitation defence must be reasonably arguable, and that has to be judged necessarily on the material before the court. Here, the only relevant alternative limitation date that's been developed by the defendants in oral submission is that based on the publication of the 2016 TCCs in the official journal of the federal government on the 29th of November 2016, based on paragraph 39 of the MPOC. That is the only potentially material event in the agreed chronology and on the pleadings fitting within the period 27 September 2016 to 23rd January 2017. And we make 2 points about that. First, that alternative limitation defence would not be prejudiced by relation back as regards the 22nd of November 2019 amendments. And secondly, it isn't reasonably arguable as a limitation defence on the Brazilian law evidence before the court, since the defendant's own Brazilian law evidence specifically opines, in reliance on Brazilian case law, that the 3-year limitation period would not have run from the publication of the TCCs. In other words, the alternative limitation defence being alluded to by Mr. Kennelly is disavowed by his own expert, and it is not independently supported by the claimant's expert. If, but only if, your lordships were against me on this last point, and you considered that there is a plausible evidential basis before you of an alternative limitation expiry on or about 29th November 2019, then that would only be potentially relevant to the 23rd of January amendments. And it would be open to you to dispose of the CPR 17.2 application if you were persuaded to grant the extension of time that is sought retrospectively, and which of course we resist. But if you were so persuaded, you could grant that extension on terms, and indeed deal with the disallowance application on terms that the 23rd of January 2020 amendments are only allowed to stand on the basis that they are deemed to take effect from the 23rd of January.
Can I just talk around that for a moment? I mean, there are different ways in which this sort of issue might arise. One of them might be this. Suppose that it's not an implied sanction case, so that Mr. Kennelly can say, please, court, in the exercise of your general discretion, allow us to make the 17.2 application late.
Yes.
Now, it might be said that were your side offering an undertaking, that you would not seek to argue that any of the later joinders had retrospective effect, would be a factor to be taken into account in deciding whether we should exercise our discretion to extend time.
Yes.
So, to
I can see that.
whether on that basis or another, at the moment you've spoken about the January editions,
Yes.
but more generally, are you? And you probably want to think about this and take instructions, but it would be interesting to know whether your side were willing to give an undertaking not to contend that any of the joinders had retrospective effect.
Yes.
Now,
I can take. I will take instructions on that. I can't tell you obviously immediately what the answer is, but I understand the purpose of your question, and I will take instructions as soon as I can.
plainly, if you're right in your case, that's not in the least bit to your prejudice.
Indeed, and moreover, even if Mr. Kennelly were right in relation to his alternative limitation defence, it might fairly be said that my clients shouldn't be concerned about that either. So I understand why you raised the point, and I will consider it. Thank you, my lord. But just to, for the moment at least, if I just round off on this topic, I think my Lord Justice Nugee raised a question about the respondent's notice. I say that's not an issue in a case where essentially you are being asked to extend time retrospectively, and you're being asked to exercise the discretion afresh. And in my submission, particularly in circumstances where the point about the November 2016 date is being developed in far greater detail than it was ever put at first instance, in my respectful submission, it would be perfectly open to you as a matter of discretion to take that into account as necessary when determining whether to disallow, and if so, on what terms, or on what terms to refuse to disallow. So that's what I say about the main item of prejudice that my learned friend has developed.
Can I just be sure? The judge dealt with the 17.2 application by deciding to refuse relief from sanctions. So she never exercised, she didn't even exercise the discretion sort of in the event she was wrong type.
You're right, except that she certainly indicated that even if she hadn't been, even if she hadn't decided what is now ground 2 in the way that she did, she obviously decided very clearly what her views were in relation to both the question of both what are now grounds 1 and 2 at first instance. In other words, she decided that there was the requirement for prejudice.
Ground 1, as we discovered, was made very clear yesterday, really contains 2 points. One is the question of principle, which is a matter of reading the authorities, deciding what the principles are, and the other is the application of the facts in this case.
Yes.
And we have the judge's view on the question of principle. Do we have any indication of her views on the application of the facts of this case?
We do. She decided that there was no prejudice on the facts of the case. By reason of relation back in the light of what she understood to be the limitation defences.
Where do we find that?
You will find that. Paragraph, it's really the discussion starting at paragraph 75 and culminating in her conclusions on the facts as to prejudice in paragraphs 80 to 82.
I mean, in this hypothetical world, we would have concluded that there is a possibility of the defendants losing a limitation defence. on that basis, insofar as the judge took into account the fact that there could be no prejudice to the defendants, she was mistaken.
Yes, she seems to have approached it on the basis you look at the defendant's pleading case and that's it. And that case isn't prejudiced. But I think you accept
Yes.
the inquiry has to be wider than that.
Yes, I do accept that. I do. Yes, and I think to be fair to the judge, because obviously, and this is no criticism of anyone, and certainly not the other side. This particular point, that obviously my learned friend has developed at much greater length. In fact, it's prompted, following the break by his juniors in relation to what he said in paragraph, sorry, no disrespect, in relation to paragraph 48 of his skeleton argument. That point hardly featured at first instance.
Yes, well,
But that's by the by. I'm not making. I'm simply explaining why the judge approached it in the way that she did, in slight defence of her.
Anyway, I think you accept that if we accept ground 2 and we think that it's an appropriate case to extend time,
Yes.
then we have to exercise the discretion afresh, and all options are open to us.
Exactly. Yes, that's the short point I make, and I can well understand that in that context, your inquiry as to undertakings is a perfectly legitimate question. So I will take instructions on that. But going back to prejudice, there was one form of prejudice that was alleged for the first time in my learned friend's skeleton argument, rather than in his rather than at first instance, which I just want to deal with very briefly. And that is, he says, prejudice. This is paragraph 46, as well as paragraph 40 of his skeleton, where he refers to prejudice to the defendants of not being able to rely on CPR 19.6 if there is no disallowance of the amendments. And we say that argument is actually very difficult to follow because CPR 19.6 is one of the exceptions to the prohibition against amendment, and allows the addition of parties after the end of the relevant limitation period. That's what it does. We accept that we, the claimants, can't take advantage of those provisions so as to bring into play the exception to section 35(3). What that means, therefore, is that the defendants are fully able to rely on CPR 19.6. They are fully able to rely on it and have taken full advantage of it. And we have conceded that they are able to do so. So I probably have misunderstood, therefore, the point my learned friend is making. But if it is being said, literally, as it is put in paragraphs 40 and 46, the prejudice arises to the defendants in the form of their being disabled from relying on CPR 19.6. Not so as a matter of fact, quite the reverse. The only other point I think I should briefly deal with is the Ladd-Marshall point.
Do you need to deal with that in circumstances where you're not objecting to us looking at the draft and?
No, absolutely not. No, sorry, what I meant by let me deal with the Ladd-Marshall point, I mean let me deal with the 2 points arising out of the amended pleading.
Yes.
That my learned friend relied upon as indicative, he says, of
yes.
a scenario of potential prejudice. And the short point I want to make about that is the following. That there were 2 elements of the pleading, as I recall, that he relied upon. First, the plea of the extended infringement period. And second, the plea or proposed plea, because of course those are only proposed amendments. The moment the hearing of the application, I believe, is listed for October. But the second point is the proposed plea of the disapplication of the limitation period under the 1984 Act. Now we say neither of those points can possibly throw light or greater light than we have seen so far in relation to the debate as to prejudice through relation back in relation to the pre-service amendments, because those are new alleged acts of infringement in relation to which, obviously, the calculus in terms of reasonably arguable limitation defense and prejudice or not through relation back, as the case may be, will have to be addressed afresh in the context of that application. And of course, that calculus will depend upon the arguments that are then developed. The court can't begin to speculate what that might be. But what the court can say here and now is that it's impossible to see beyond the arguments we've been exploring now in relation to the pre-service amendments. It's impossible to see how the arguments that might be relevant to the limitation and prejudice calculus in relation to the much later events of infringement could possibly affect the analysis we've been embarking upon already. If my learned friend's point is simply that, well, there's a possibility of amendment, well, of course, there's always a possibility of amendment. And as I said yesterday, one obvious possible scenario is where a defendant advances no limitation defense whatsoever at the point of a particular proposed amendment. And the amendment is then made, and then sometime later comes forward with the limitation defense, which potentially, if it had been raised earlier, might have been a real objection to the earlier amendment. That's just the vagaries of litigation. And the court doesn't try to foresee all possible developments in the case. As far as the second point is concerned, the plea of disapplication of the limitation period, well, again, it's impossible to see how that throws light on the debate we've been having, because the effect of the disapplication of the limitation period will be to improve the claimant's position. In other words, to make the claimant's case on limitation, such as it is, which is currently at the earliest, a limitation expiry of the 6th of March 2021, would be to make that stronger. And that simply means that limitation becomes even less relevant, not more relevant. And so pointing to that, therefore, in my respect, the submission is of no real relevance to the issues before you on the appeal.
Sorry, this may be obvious to everybody else, but why does it become stronger? Because you would be relying on Section 32 if it was English limitation?
Well, forgive me, what I mean by stronger is simply that if there were a basis for disapplying limitation, but, for example, we were wrong on when the date of knowledge was, for instance, it's conceivable that if there were a basis for disapplication, we end up in a better position than without a disapplication. But I accept...
Because you would apply English law rather than Brazilian law of limitation?
Yes.
Yes.
Yes. But it's not even speculation I necessarily need to embark upon. The other side, nobody's suggesting that the effect of the disapplication would somehow make the narrow window between September 2006, September 2016 and January 2017 suddenly relevant to the limitation analysis. So it's by the by in my submission. So that allows me to turn to ground two. Now, I understand that obviously, having considered in great detail ground one, ground two may be thought of as almost a sort of subsidiary point. But I want to be very clear, my lords. Ground two, obviously, is a very important point. And it raises some important points of principle too, which obviously have to be grappled with. So let me start with the key facts. You know what they are, but just very briefly. The Viegas Claim form was originally issued on the 27th of September 2019. It was then amended on the 22nd of November of the same year, and then later on the 23rd of January of the following year, prior to its having been served on anyone. The amended Viegas Claim form was then served on the first defendant in England on the 27th of January, and on the second defendant in Switzerland on the 26th of February.
Just remind me of the
2020. Yeah, date of, year of service.
And the amendments, we haven't looked at the amendments, but they simply consist of change of parties.
Yes, essentially.
Addition of some parties, removal
Well,
of other parties?
we can have a quick glimpse at it. In fact, it's something that I was going to take you to later anyway, but we can have a quick glimpse at it. In tab 2 of the core bundle.
Tab 2?
Sorry, not tab, volume 2, forgive me, tab 22.
22.
22. You will see that
So we've got red amendments in November 2019 and green in January 2020.
exactly, and there's a little explanation at the bottom of page 324 of the chronology of the amendments. And essentially, the red amendments consisted of a number of changes. If you look at page 327, which is the beginning of the schedules of the various claimants, a number of changes of detail, primarily, but occasionally more substantial in Schedule 1, which was always there right at the outset. And then from 22nd of November 2019 onwards, if you look at page 332, the addition of more substantial numbers of claimants. First in red, and they are by far the longest list of additions, and they run from page 332 all the way to
So you started off with some 150 claimants,
yes.
and then by your amendments you added a very large number of extra ones.
Yes, there were about 1,300.
But you didn't change the nature of your brief details of your claim. It's purely a question of communal parties.
Yes.
Thank you.
And then you can see the January 2020 amendments on page 364 onwards.
Yes. Thank you.
And thereafter, so far as the 17.2 application is concerned, the first defendant's application under CPR 17.2 was not made until the 19th of November 2021, almost 1 year and 10 months later. And the second defendant's application, similar application, was not made until the 11th March 2022, a little over 2 years later.
Had it been flagged in correspondence before then?
No. The earliest flag, if I can put it that way, was the flag on the 7th of June 2021, but it was a fairly uninformative flag. And if I may, I will come to that as part of the history on supposed prejudice.
Can I just get the dates clear? Actually, I'm looking at the chronology. So the first defendant's application, this is page 377, is it? So it's the 19th of November 2021.
Yes.
Yes, I see. And the second defendant's was 11th of March.
11th of March, which you can see over the page,
Yes, I see.
378.
Yep.
Fourth entry. And there was a yet further one on the 21st of March, but that did not concern the 17.2 application. That was a further application on other grounds which don't concern this court.
Yeah.
So the first argument that's deployed by the defendants is the so-called implied extension argument. And I think it's important to understand the formulation of that argument. And you will see that in the defendant's skeleton argument, because I don't think that it's set out anywhere else. And the way they put it, and just to be clear, the original application notices were only for relief from sanctions. They were not for an extension of time. You can see that, in fact, in the application notices, just for reference. I'll give the references in a moment, if I may, but I'll carry on in the meantime. The implied extension is put as follows in paragraph 56, that CPR 17.22 must be read so as to permit any application under CPR 17.21 to be made at the same time as the filing of any further acknowledgement of service under CPR 11. 11. So, so it is said that, otherwise it is said that a defendant would be at risk of being held to have submitted to jurisdiction by making the application at 17.2.
You're being offered a post-it from behind.
Thank you. And thank you, my lord. And the references for where you will see the reference to the prayer for relief from sanctions is in the supplemental bundle, tab 1, at page 2. Page 4, forgive me.
That seems to go beyond just relief from sanctions.
Yes, forgive me. What I meant by relief from I don't mean that the relief was only the relief claim was only for relief from sanctions. What I mean is it was for relief from sanctions rather than for an extension of time, for a retrospective extension of time. That's what I mean. So far as that.
But if the sanction is an implied sanction,
Yes.
you can't bring the application after the 14 days, which is the argument.
Yes.
If you're granted relief from that, that is giving you an extension of time, isn't it? Isn't it just a semantic point?
Well, it's a semantic point, save to this extent, that when they applied, one might say it's a bit of a jury point, because at the end of the day, I'll either persuade you that there is an implied sanction or I won't. But the point I'm simply making is that certainly when they applied for the relief, their assumption was that there's an implied sanction. And in fact, Mr. Cassels, in his supporting statement...
Well, no. The first defendant should be... I mean, it's probably not necessary to take up time on this, but the first defendant should be granted relief from sanctions pursuant to CPR Rule 3.9 if there has been non-compliance of a deadline.
Yes.
So
yes.
That's not an assumption that there has been non-compliance. That's an assumption that it might be said that there's been non-compliance.
Yes. I think it's my fault for being unclear as to what I'm saying. So just to be clear as to what I'm saying by my reference to this particular point, the other side have always had this point, this implied extension point. That's been part of their case throughout. That's
But what is the jury point then?
But if there was contravention of the time limit, they impliedly accepted that there was an implied sanction, or they accepted that there was an implied sanction. And Mr. Cassels...
They're either right or they're wrong. They may have been wrongly generous to you.
That's why I said it's a jury point, and I've spent already too much time on it, but I shall therefore move on. But going back to the main point itself, we say there are 5 reasons why the argument of implied extension should be rejected. The first is that it is entirely unsupported by the plain language of the rule, which provides for a 14-day time limit for any application that a party may wish to make for an order to disallow pre-service amendments. The language of the rule evinces no intention whatsoever to regulate the operation of the time limit by reference to any other step taken or application made under other parts of the CPR. That's obvious. Secondly, and what is more, the 14-day time limit is expressed to run from service of a copy of the amended statement of case on the relevant party. And we say the meaning of this language is clear and unambiguous. It doesn't tie the time limit to the filing of any acknowledgement of service, whether a first acknowledgement of service under CPR 10.3 or a further acknowledgement of service under CPR 11.7 after the determination of the jurisdiction challenge. And so the implied extension proposed by the defendants conflicts with the express language of CPR 17.2 and we respectfully submit fails to meet one of the fundamental prerequisites for any form of implication. Thirdly, had the CPR author's intention been to qualify the operation of the 14-day limit by reference to the existence of a jurisdiction challenge under CPR 11, it would have been very easy to do so. The regime for challenging jurisdiction under CPR 11 is very well established. The CPR is replete with examples where the operation of one rule is expressly made subject to or qualified in some way by reference to the operation of another rule. Yet no extension to the 14-day time limit in CPR 17.2 has been articulated by reference to any of the steps described under CPR 11. Of course, we don't say that that is a determinative consideration, but it's a persuasive pointer away from the implication contended for by the defendants. Fourthly, the suggestion that without an implied extension, there would be a risk of submission to jurisdiction by applying under CPR 17.2, we say with respect, is misconceived. There are at least two obvious ways and safe ways in which any real risk of submission to jurisdiction could be eliminated in practice. The first would be that a defendant who wishes to defer making an application under CPR 17.2 until after the determination of its jurisdictional challenge can make an in-time application within the 14-day time limit for an extension of time under CPR 3.12a for the specific purpose of enabling the determination of a jurisdiction challenge first before the determination of the CPR 17.2 application itself. There are many situations where litigants have had to resort to this measure when faced with an impending time limit, including, certainly I can speak from my own experience, including when limitation challenges are pending.
Do you mean jurisdiction challenges?
Including when jurisdiction challenges are pending. And there could be no conceivable basis, we respectfully suggest, upon which an in-time application for an extension of time for the specific purpose of enabling jurisdiction to be dealt with first could possibly be construed itself as a submission to jurisdiction. It would be entirely for the purpose of allowing jurisdiction to be determined first, while simultaneously protecting the party's right under a particular rule of the CPR and to avoid any misunderstanding or misconstruction. Alternatively, and this is something that I have done and that I've seen done regularly in commercial litigation, a defendant can file an application 17.22 within the 14-day time limit, but can make clear in the application notice itself that it is making the application conditionally if the court were to decide, contrary to that party's primary case and pursuant to whatever application notice it has already issued or is about to issue, if contrary to that party's case, the court rules that it has jurisdiction, and in that event seek the relief that is justified or claimed under CPR 17.2. And that is, again, a situation where the explicit reservation on the face of the document itself, of course, we've all seen judgments such as, for instance, the Zhivago judgment where the Chancellor dealt with a situation where the reservation was not in the application notice, but came in an order that came after the application notice and a witness statement which dealt with an application to strike out first rather than the application challenging jurisdiction, although it dealt with both topics. And one can see how in that kind of situation you might have a bit of an argument. But if you do it properly, right from the outset, as litigants often do, there can be no real risk of a submission to jurisdiction. And it's very hard to believe that parties such as those on the other side, if they had really wanted to, of course, we don't know, in fact, what all the calculations were at the relevant time. And one can speculate, but I don't need to waste time doing that. We don't have to answer that question. But the axiomatic question of what could be done pursuant to the rules, the answer to that in my respective submission is very clear. So those are two very simple ways. I'm sure there are variations of that one could think of, whereby one's jurisdictional position can be firmly protected without any serious doubt, which, in my respectful submission, blow a large hole in the notion of necessity that my learned friend has effectively created to justify the implication. And what is significant, and in my respectful submission, informative, if you're trying to construe the CPR as a whole, and come to because one of the points that I'll come to in a moment is we're talking of implication into the CPR. This is not like a contract between businessmen where one says, oh, well, surely they must have thought about that, and let's try and think of some reasonable, commercially minded solution that we can presume they must have intended. This is a document that is intended to be clear, easy to understand, and universally followed by the legal community. So the idea of implying willy-nilly wording that you want because of some difficulty that you found yourself in on particular facts, when there might have been other ways of dealing with the problem, that, in my respectful submission, is an argument that the court should be very wary of acceding to. There are no doubt many other interactions between different parts of the CPR where potential conflicts or inconsistencies or tensions could be identified. And if the mere existence of that were to start to be a basis for hard implications of hard-edged rules of the kind that's being argued for by the defendants, that, in my respectful submission, is a recipe for great uncertainty. But the point I was going to make is this, that in each of the two scenarios that I've just described, it would be necessary, in order for the defendant to avail itself of the safety of an extension of time, whilst protecting its position, it would, of course, be necessary for a defendant to explain why that should be so. And of course, had such an explanation been provided, which would have been no doubt very persuasive, and one would think would almost certainly have compelled a reasonable counterparty to agree to the extension, or alternatively would almost certainly have led to the court to make the direction, the advantage of that course being taken would have been that information would then have had to be provided as to the basis for the extension and as to what the grounds are for challenge under 17.2, which it would be said couldn't be immediately embarked upon pending the outcome of the jurisdictional dispute. And of course, if that is what had happened, then obviously a suitably warned claimant might have been able to protect itself alternatively as well, which in turn might well have either disposed of the problem altogether or at least reduced the urgency of the disallowance question. But that is perhaps an incidental benefit, it might be said, of those courses of action. But the fact that those courses of action would have had that beneficial effect, in my respectful submission overall, is a further reason for questioning very severely the notion that those courses of action were completely out of the question, and that instead the court should simply succumb to some unjustified fear of a risk of submission to jurisdiction of the kind described. And so what we say is that once it's appreciated that there are straightforward and effective procedural mechanisms by which a defendant can preserve its jurisdictional objection in the manner I've just described, the supposed necessity for the implied extension vanishes. But we also say that the defendants have in any event sought to exaggerate the risk of submission in an effort to manufacture the supposed necessity for the implication. And I just want to show you the authorities very briefly.
We've been taken to an extent, the authorities.
Yes.
And I'm conscious that we're running behind time.
Yes.
Is it going to be good use of time to
Well,
perhaps
can I
just give
show
us some
you
references?
Can I just show you, can I ask you to take account of two authorities?
Yes.
I won't take you to them. The first is this. My learned friend took you to Grant on civil fraud and showed you paragraph 39-069. What he didn't show you right below it, and that's the paragraph that says, well, an application or even a threat to apply to strike out could be a submission. But immediately below that paragraph, there is a very clear statement based on the Court of Appeal's judgment in Cosa and Axel, which was overturned on a different point in the Supreme Court, but is good law so far as the submission point is concerned, which states that none of the steps described in the paragraph that my learned friend took you to, those steps will not amount to a submission if the party at all times clearly and expressly reserves his objection to jurisdiction. And in fact, in Cosa and Axel, on the facts of that case, there was actually a counterclaim, but all entirely conditional and very clearly so expressed and maintained all the way through. But for case management reasons, it had to proceed in that way and the defendant had no choice. But nevertheless, whilst an appeal was pending on jurisdiction, its jurisdictional objections and rights were preserved. Dicey and Morris, I ask you to look at paragraphs 11-067 and 11-068, where the common law waiver test of an objectively clear and unequivocal abandonment of the right to challenge jurisdiction is articulated based on this court's decision in a case called Petramina and Deutsche Bank. And the statement in particular at 11-068 that the clear trend of the modern authorities is that the defendant will not be regarded as having submitted by making an application in the proceedings, provided that the defendant has specifically reserved his objection to jurisdiction. And that is very much in line with Chancellor Fleur's reasoning in Zhivago. The fifth, so in sum, therefore, we say the authorities before the court support the proposition that a defendant's clear and express reservation of its jurisdictional objection ought generally to insulate itself from a finding of submission to jurisdiction as a result of taking another step in the proceedings. And in the light of that, in my respect to submission, Dame Moulder was entirely right to reason as she did at paragraphs 116 to 118 of the judgment, which I won't take you to. The fifth reason, my lords, is this, that even assuming that the risk of submission is real, rather than fanciful, which is my primary submission, but even assuming it is real, it does not logically flow or follow from the existence of such risk that the implied extension is justified. And I say this for the following reasons. An application under 17.22 may be based on arguments that do not require the parties and the court to enter into the merits of the claim and adjudicate upon the substance of the claim. It covers a whole range of possibilities whereby a party may seek an order for disallowance. And of course, we are approaching the point as a matter of principle at the moment without reference to the particular facts of any case. Yet, despite the broad range of situations that may give rise to an application under 17.2, the implied extension contended for by the defendants does not discriminate between those applications that require an assessment of the merits and those that do not. The risk of submission, the existence and precise magnitude of which, in any particular case, would be intensely fact-sensitive, cannot reasonably justify the wholesale and indiscriminate rewriting of CPR 17.2 in the manner suggested. Putting it differently, there is a mismatch. There is a mismatch between the reason that is relied upon as justifying the implication, i.e. the risk of submission to jurisdiction, and the scope of the proposed implication. But further still, even if the risk relied upon were real, in my respectful submission, its existence merely entails that a defendant would then have to make a choice between, on the one hand, maintaining its jurisdiction challenge and not applying under CPR 17.2 to disallow pre-service amendments, but applying instead, for example, to strike out pursuant to CPR 3.4, where there is no time limit. That's an option that is open to them. And indeed, their own application notice in this case is an application to strike out and or disallow the amendments. On the other hand, and that's the other choice, they could apply under CPR 17.2 with relevant caveats, and if necessary, run and confront any supposed risk of submission, whilst maintaining their jurisdictional challenge. In other words, the existence of a risk does not create any compelling necessity for the implied extension. It simply means that the defendant has a choice to make between different courses which may have their own advantages and disadvantages. But that does not mean, in my submission, that CPR 17.2 as it stands would be rendered meaningless, unworkable, or incoherent without the implied extension being proposed.
May I just check that I understand that last submission? Are you saying that they could make an application at any time under 3.4 on the same basis substantively as they could under 17.2, namely that the amendments shouldn't have been allowed because they prejudice a limitation defence?
Not exactly the same basis. No, not exactly the same basis. But it very much depends upon the argument that they have. Their argument could, for example, be you could apply to disallow, for instance, on the basis that you have an unanswerable limitation defence. In that case, you might be able to proceed both by way of a 17.2 application and a 3.4 application. I'm not suggesting, in case this is what I was thought to be suggesting, I am not suggesting that there may not be an area of operation for 17.2 that is, as it were, unique to it and would have no equivalent in the context of a 3.4 application. But there is clearly overlap depending upon the type of application and your argument that you want to deploy. And so, and this in a way goes back to my point about the nature, this very hard-edged implication that they've put forward, which ignores all these nuances of the various rules that provide you with various possibilities, not all of which are overlapping or equivalent, but where the existence of overlap with peculiar advantages and disadvantages, and depending upon the particular rule you're looking at, militate against an axiomatic qualification of the kind that my learned friend is suggesting. And then if you, so the answer to that might be, well, hold on a minute, okay, well, that's not such a problem. Maybe we can fashion some more, a narrower implication that will only cover the area of operation of 17.2 that is not replicated elsewhere in the CPR. And moreover, we will only imply it where there is a specific type of application that might engage the merits. In a sense, that's what my learned friend would have to do. But if you put it that way, you then end up in a surreal world where you're having to define the implication in terms that are simply improbable in terms of what the CPR authors intended.
I have a concern about time.
My lord, yes, I'll
And,
move on.
I think you've made the point.
Yes. So, my lord, that then takes me to the question of relief from sanctions against extension of time, and which is their second argument. And there are three steps in that argument, as I understand it. They say that relief from sanctions, which they applied for and were refused in the court below, was not required because there is no express or implied sanction, and they say that the court should extend time, etc. So we have two answers to that. First, we say that Mr. Justice Mann was right in G4S to conclude that non-compliance with the time limit specified in CPR 17.2 carries an implied sanction. We consequently disagree that the only real issue is whether to extend time in accordance with the overriding objective. And we say that, and secondly, we say that if contrary to our primary submission, it's necessary for this court to exercise its own discretion whether or not to extend time, the court still operates on the basis of the Denton ethos, and would in any event, be unjust and contrary to the overriding objective to grant the substantial retrospective extension that's being sought. So can I take these points in turn? The first is, does 17.2 carry an implied sanction? It's common ground there's no express sanction. It's common ground also that CPR 17.2 does not impose a duty on a party to apply for an order to disallow. What it does is to create a right or entitlement, not an obligation. But what it also does, and I don't think that this is in dispute, is that if a party wishes to avail itself of the right that is offered by 17.2, then it must exercise that right within 14 days of receipt of a copy of the amended statement of case. So the time limit is mandatory if you wish to take advantage of the right. And this particular interpretation of CPR 17.2 was established after detailed consideration by Mr. Justice Mann in G4S, following which he went on to adopt the view and decide that it carried an implied sanction, the sanction being built into the very architecture of CPR 17.2, which is the loss of the right to claim disallowance, very much like the appeal cases, or indeed the appellant notices example, or the respondents notice examples, where there is, of course, no duty to appeal, no duty to run extra arguments on appeal. But if you choose to do so, you have to observe a time limit. And if you don't, then the implied sanction is you are stuck with where you are, and you lose the right.
I quite follow how the appellant's notice line of authorities fits with that analysis. But there is an alternative analysis. I mean, suppose you have a case management conference and the judge gives directions, including the defendant is to serve his defence by such and such a date. Now, plainly, you don't have to satisfy the Denton criteria to ask for an extension of the time.
Well, if at that point there's been no breach, then
well, even if you miss the deadline, you don't have to satisfy Denton criteria to be allowed to put in a defence.
Well, I think
or do you say you do?
That's too broad a statement. With respect, if you miss a deadline that is contained in the rules, and in fact, this is
well. At the moment, I'm not in the rules. I'm saying case management conference, judge makes an order, defence to be served by such and such a date.
If it is simply a breach of an order per se, with which is not an unless order, let's say, so there is no sanction, then I can see there may be an argument that there is no implied sanction. But it very much depends on the type of order and the subject matter of the thing. Let me give you an example. In Lufthansa,
Just before you come to Lufthansa, to make it closer to our situation, suppose the judge makes an order that the defendant is to do such and such a thing, if so advised by a particular date, or is to do serve such and such a thing, if any, by whatever. So that again, the party has a choice as to whether to do it. I'd be a bit surprised if that meant that there was an implied sanction when there wasn't otherwise.
well, I think again you're positing a situation where there isn't necessarily the loss of a right to do a certain thing. If we analyse it, if we look again at the appellant's notice situation, it's very clear you're not obliged to appeal if you don't want to. It's a right that you're offered by the rules. But you can only exercise it within certain time limits. And if you don't, and you have to get permission of the court, i.e. an extension of time, that is treated intrinsically as an implied sanction case, the implied sanction being the loss of the right to appeal, with the consequence that you're then stuck with the first instance judgment, with no ability to challenge it. That is clear, and that is the Sayers, Altamart, as well as the Heisage line of authority. That's very clearly established. And if you ask yourself, well, why is that? And it's very clearly set out. I'm probably going to run. I don't have time to go to all of these cases, of course, but we'll see that. I will take you briefly, if I may, to the Yes Electrical case, where there's a summary of 3 categories of case where the relief from sanctions jurisdiction is engaged. If we look at that briefly, paragraph 27 of Yes Electrical. In case your lordships are concerned about time, what we have agreed between us, just to put your minds at rest, is that any extra time that either of us takes in the first appeal will come out in the second appeal.
That only partly reassures me, because we might want some extra help on the second appeal.
Well, of
we
course, I
don't want to
it's quite
find
complex,
that.
perhaps even more complex. So I understand. So, my lord, if I can ask you briefly to go to tab 59, and if you look at paragraph 27.
In which paragraph?
Paragraph 27. So this is summarising the 3 categories of case where relief for sanctions is required. The first is cases where the rule or order expressly provides for the sanction that will apply on non-compliance. For example, failure to file witness statements on time. I think the implication being that the express sanction is you're not allowed to lead evidence at trial, and that's treated as an express sanction. So perhaps, in fact, that addresses
I think
your example.
I'm not actually sure it does. To be honest, I forget this, but I think that has in mind a specific previous authority dealing with a specific rule which says something beyond just...
You may be right that there is an express provision of the CPR that says that if you don't do it on time, then you're not allowed to adduce evidence at trial, and therefore, in that sense, it's express, as in it is to be found in the CPR. I accept that. The second category is really the relevant category for present purposes. Cases where the rule does not expressly state the sanction which applies to non-compliance, but permission of the court is needed to proceed. Now, I understand obviously that the language of to proceed is arguably equivocal and doesn't necessarily explain precisely what it is you need to be prevented from proceeding with. But certainly the category of case that's been treated as falling, the type of case that's been treated as falling within that category, is those cases where a right can be exercised, but has to be exercised within a certain period, but is not. But what was interesting in the FXF case was the court went on to deal with a third category of case, where in fact there is no immediate automatic sanction, either expressed or implied as per the first two categories, but where a further step can be taken by the other side in consequence of non-compliance, such as the entry of a default judgment or the striking out of a claim for non-attendance at trial, where also, notwithstanding the absence of an express or implied sanction, and a further step by the other side is necessary, the court nevertheless considers that the relief from sanctions jurisdiction should be treated as being engaged. So it's actually a broader jurisdiction than the language of sanctions might imply. For present purposes, what we're concerned with is the second category. Now, I don't have time to take you to all of the authorities, but can I give you some relevant references to look at in due course? Sayers, paragraphs 17 and 21 in particular, where the implied sanction is inferred from the loss of the right to appeal if the time limit is not observed. Salford Estates and Altamart, paragraphs 13 to 16. Again, no obligation on the part of the respondent to serve a respondent's notice. If it chooses to do so, it has to do so within time. And there's an implied sanction because without extension, the respondent is prevented from seeking to uphold the judgment on additional grounds. Hysage, another case of filing a notice of appeal out of time, endorsement of the concept of implied sanction in the form of the loss of the right to pursue an appeal. And we say that the situation of the loss of the party's right to challenge pre-service amendments under CPR 17.2 in the absence of extension of time, with the consequence that the pre-service amendments continue to stand as the amending party's pleaded case, should consistently with that same line of authority and reasoning be treated as an implied sanction that brings the Denton principles into play. The sanction in the form of the loss of the right or inability without the intervention of the court to seek to disallow pre-service amendments, we say is intrinsic to the operation of CPR 17.2. And in fact, one might say, in that sense, it's a scenario of an implied sanction, which is closely analogous to an express sanction. And that was essentially, Mr. Justice,
There's this difference. I mean, if you're trying to get the notice of appeal in, the duty is on you, the putative appellant, to do it. And if you don't do it, that then features implied sanction. But looking at 17.2, what's happened here is you've made amendments without having the need to get permission of the court in advance. And 17.2 has headed power of court to disallow amendments made without permission. If a party has amended their statement of case where permission was not required, the court may disallow the amendment. So it's an additional protection, if you like, where people aren't required that things can happen. And true it is, a party may apply to the court for an order under that, but it's not quite the same. It's not, as you put it, the right of the individual to have the amendments disallowed in the same way as if somebody wants to appeal, they've got to put their notice of appeal in. Here, you, the claimant, have been able to do something without permission. The courts can stop that, and the person concerned can apply for an order, saying to the courts, please stop that.
Well, with respect, it's not a relevant distinction or difference, because in both cases, all that you have the right to do is the right to ask the court to grant certain relief. And the point is, both in the case of the out-of-time appellant's notice and the out-of-time disallowance application, what you lose the right to do is to ask the court to grant the relevant relief, be it the overturning of the first instance judgment in one case, or in the other case, the right to ask the court to make an order to disallow the amendments. And the sanction obviously speaks for itself in that situation. At any rate, I ask your
Court disallow the amendment of its own motion without an application at any time?
Well, the court in theory can do all kinds of things of its own motion. The court can raise points parties have not raised. The court could question the adequacy of a pleading at a CMC or whenever it engages with issues in the case. What is by far, I'm not actually aware of any reported case that, as it were, explores the meaning and effect and scope of 17.2 sub 1 on its own. That section has been the subject of investigation almost always, or in fact always as far as I can see, in the context of an application being made for an order to disallow. But it doesn't matter, in my respectful submission, that the court itself may have an independent power to do certain things, because obviously the court can't be out of time, if I can put it that way. Luckily for the court, it might be said. But a party that wants the court to make an order may be out of time if that is the nature of the rule. Now, of course, there is a question as to, well, why does the rule have this time limit? And that is a point, in fact, that's addressed by the judge, and that was also dealt with by Mr. Justice Mann, which is that the purpose of the rule is obviously to ensure that there is certainty at the earliest or reasonably promptly when pre-service amendments are being made.
But you've said that that can't happen here because we know that in reality the jurisdiction thing has got to be dealt with first. So there isn't going to be certainty about the outcome. We aren't going to know whether or not those amendments will or will not be disallowed until after the jurisdiction thing. So any certainty must come only from the fact that they will be certain that at least somebody is going to be inviting the judge to invoke the power to disallow the amendment within 14 days.
I'm making a slightly different or narrower point, which is simply this, that if you ask yourself conceptually, why is there a time limit? The obvious answer, in my respectful submission, is the answer I've just given. I'm not suggesting that there may not be cause in some circumstances for the court to extend time. Of course, that goes without saying. In any case where a rule imposes a time limit, it's not an answer to say, well, it may not work in this kind of situation. The answer is, well, yes, that may be so, which is why there is this very wide power to grant extensions of time. But that, in my respectful submission, doesn't really answer the point as to whether a sanction is inherent or to be implied into a relevant rule.
So, Cutrale, you referred us to Warren and yes. I've been looking at what was said in paragraph 33.
Yes, 33.
33 by
Yes.
Lord Justice Burse, I think,
Yes.
with whom Lord Justice Mayles and Lord Justice Aspin agreed. And is this the latest word of this court on when there's an implied sanction in a rule where there's no express sanction?
It's the latest one that I am aware of.
Yes. Because what he says in paragraph 33, he says, first you have to identify if a rule has been breached.
Yes.
Well, let's park that for the moment. Well, I think there is a question about that because there's no obligation on anybody in the rule. You're not required to do anything. But he then says, if there's been a breach, the next task is to identify any sanction which is expressly provided for in the rules, and you don't suggest there's any express sanction in this rule. If there's no such express sanction, then outside the third category identified in XFF, and that's where if you don't do something, the other party can do something, get a default judgment if you don't serve a defence and so on.
Yes.
We're not in that territory. And the specific recognised instances identified in Sayers and Altamont are
Yes.
the notices of appeal and respondents' notices. There is no relevant sanction for the purposes of Rule 3.9, and so that rule does not apply.
Yes.
Now, that's his summary of where we are.
Yes.
That seems to draw a very clear distinction between the cases which you rely on, like Sayers and Altamont, where there has been an implied sanction recognised, and every other case, including this case, where if it's not there, you don't apply it. Now, that may be logically difficult to understand, but we have to follow what this court has said, don't we?
Well, I don't accept that that is what the
You don't
judge...
accept that's what he says?
I don't accept that that is what he means.
Do you accept that's what he says?
Well, on a literal, you can certainly construe it.
How do you invite us to construe it?
What I invite...
I
I understand this point, and it's the point I was going to come on to.
I'm
which
sorry
is,
to take you
no,
out
no,
of
no,
your
at all,
course.
no. It's a useful. It's always useful to have a bilateral discussion, if I can put it that way. But obviously, it does mean that some points come out of order. But there is a question, and in a way, my learned friend effectively was making the submission that the appellant's notices and the respondent's notices cases constitute a closed category of implied sanction. He said I think he kind of put it that way. I don't think he's put it as strikingly as this, but I suppose he push came to shove. That's how he would put it. But I don't accept that this judgment can be read in this way, because Lord Justice Burse here is purporting to follow the line of authority established by Sayers, Altamont, and Heisage, which I think the court will have to look at in its
Well,
own time.
he's not purporting to say that they're wrong,
He's not purporting to say that they are wrong,
but he is,
but he...
on the face of it, putting them in a box on their own. And if you go back to 31, where he expands a bit further on what his thinking is, paragraph 31.
Yes.
So he's not saying it's impossible to have
Well,
an
quite.
implied sanction otherwise, but he says the hurdle's got to be a high one, and the scope for identifying any further sanction must be very narrow.
Yes. Well, point one, that of itself tells you that he cannot have intended in paragraph 33 to be suggesting that the implied sanction category is a closed one and only to be established by reference to whether or not the factual scenarios considered in Sayers and Altamont, or indeed Heisage, exists. He can't have meant that, because if that's what he meant, none of the other statements about the approach to be adopted would make sense. Secondly, if I had to, if I'm forced to, as it were, on the basis that this court would say that the only possible reading of paragraph 33 is that is exactly what Lord Justice Burse is saying, my respectful submission would be that he was wrong. And that does not reflect the consistent line of authority from the Court of Appeal right up to, indeed, Lufthansa and FXF, where the implied sanction category, in fact, as recently as Lufthansa, and indeed as repeated by Lord Justice Burse himself in paragraph 27, treats the second category of case that attracts the relief from sanctions jurisdiction as being a generic category that has to respect the criteria that is set out in Roman 2 of paragraph 27, i.e. cases where the rule does not expressly state the sanction which applies for non-compliance, but permission of the court is needed to proceed, e.g. failure to file a notice of appeal on time, not only failure to file a notice of appeal on time. And so if you construe the judgment as a whole, including what preceded it in Lufthansa and FXF, and paragraph 27 and paragraph 31, and you then come to 33, in my respectful submission, what he was really getting at at most in paragraph 33 is that the court should obviously be slow, perhaps very slow, to expand the categories of cases of implied sanction. But he was not seeking to suggest that the only possible implied sanctions cases would be the ones where there's an appellant's notice or a respondent's notice. And that would simply not make any sense.
I mean, I can't see any inconsistency between yes and Lufthansa. I mean, Lufthansa was concerned with a different situation, but
Yes.
The remarks you get in, say, paragraph 22 of Lufthansa don't conflict with what Lord Justice Burst later says in yes.
No, but in fact, if you look at Lufthansa on page 1574, for instance, paragraph 21, you will see that he has no difficulty with the reasoning and the whereby a sanction is implied from the loss of the right and the implied sanction in the form of the fact that without the relief, an extension of time, i.e. an extension of time, the thing in question could not be done. That general principle he doesn't have any difficulty with.
Well, appeal notices are different. I mean, it's a two-pronged thing. You must get permission to appeal. We had the Access to Justice Act and we decided that there weren't going to be whole-scale appeals, so you must get permission, save in certain categories. And you must do that within a certain timetable. And you can see then how you might say, and if you don't do that, the onus is on you. You've got to get permission. You've got to act within a certain period of time. And if you don't, then it's consistent with the structure of the Act that the appeal is lost. And that's a slightly different thing, is it, from where a court is given power to disallow what another third party has done, and that can be activated by the action. You're not dealing with equivalent situations, are you?
Well,
But you said they are. You say they are. You say no.
I've said what I've said. I will simply repeat it myself. And so far as your point about permission to appeal being irrelevant ground of distinction, with respect, it's not least because the point that the established case law treats the failure to serve a respondent's notice, for which no permission is required on time, to be in the same category of situation.
Yes.
Can I just, as you say, I think we've been over this ground, but just to be clear, what do you say the ratio of yes is?
The ratio of yes is simply this, that the court must consider carefully whether there has been a breach of the rule, practice, direction, or order. And by breach, just to go back to Lord Justice Nugee's point about, well, could it be said here that there's no breach? Breach is to be understood in the sense of failure to comply with a rule, practice, direction, or order. In other words, breach in the sense of contravention of the relevant rule. And obviously, there is a contravention of a rule about a time limit in relation to the exercise of a right. If you choose to exercise it outside of the time limit, and you need the court's permission to do so. So it's emphasizing the importance.
Just pausing there,
Yes.
and I'm afraid I haven't looked properly at the facts of yes. Was a finding that there was no breach the basis of the decision? I mean, if it wasn't
I think in
the
that
basis of the
case,
decision, then that's not the ratio.
Paragraph 43, I think.
I think that there was a question about breach.
But
And then at 43, as has just been pointed out, the judge decided that the
yes, I see.
claimant is not complied.
But he hadn't reached in the sense of the use of that word in the sanctions. It looks as if that's what 43 is saying. Paragraph 43.
But in 44, he says the question then is whether 35.4 is a sanction for the breaches identified. So something, there must be some breach.
Yes.
So at least part of the ratio is there is no implied sanction. So when I say that's the conclusion, what is the reason for saying that there is no implied sanction? That presumably is part of the ratio.
Yes, I don't, I wouldn't suggest that, it's not my submission, that, paragraph, that any particular part of paragraph 33 should be treated as being obiter, if I can put it that way. I think that would be a case of my trying to nitpick too much with paragraph 33, if I can put it that way. Although obviously one does have to be careful. But I simply say that paragraph 33 cannot fairly be read in a very narrow way that might be suggested when you look at the judgment as a whole, and in the context of the judge seeking to give effect and summarize previous case law rather than, as it were, making new law. And what I say is that we other than the closed category point that might be implied or derived from paragraph 33, we say that all of the elements that are there, we satisfy. There is a breach in the sense of a failure to comply with the time limit as required by the rule if you wish to avail yourself of the right in question. So there's a breach or contravention in the relevant way. There is the implied sanction in the form of the loss of the right to seek the order in question without the permission of the court. And what is more, that sanction or adverse consequence takes effect automatically without further intervention. So that you're firmly, therefore, into the second category of case identified in paragraph 27, rather than in a third category of case where there might be need for a further step to be taken. And I ask you to look in particular at paragraph 21 as well of Lufthansa, which confirms the category of implied sanctions, which I drew your attention earlier, as well as the earlier passages in Sayers, Alto Mart, and Isage. Now, just a few final points on extension of time, which I hope to do in 5 minutes. Even if the Denton principles do not directly apply, as you know, and was confirmed in paragraph 25 of the judgment of Lord Justice Birch, but the ethos of Denton applies generally under the overriding objective, and you see that at paragraph 25. And we say, therefore, that the judge's factual findings at paragraphs 119 to 139 of her judgment below remain relevant. And I don't need to waste time summarising that. And I also say that because of how the permission to appeal was dealt with in relation to relief from sanctions, the defendants do not have permission to challenge those factual findings, and in fact have not sought to challenge those factual findings.
Well, they're not allowed to challenge, supposing that there is an implied sanction that you're into Denton, they're not allowed to challenge the judge's decision on Denton. But in terms of not being allowed to challenge matters that would bear on a non-Denton decision, they must be entitled to challenge the idea that there's no prejudice to the defendants. Because if we get into this, we will have concluded that there is a possibility of prejudice to the defendants.
Well, obviously, if the court were, as part of the first appeal were to establish certain matters which are inconsistent with what the judge decided expressly or implicitly in relation to the subject matter of that appeal, of course, your lordships would be entitled to take that into account. But in relation to matters such as was there very substantial and serious delay, the characterization of that, in terms of whether there was a good reason for the delay, in terms of whether the defendants had given fair notice of their intention to rely on CPR 17.2 in the way in which they actually eventually did, as late but relatively early or earlier on the 7th of June 2021. All those kinds of findings, as well as the potential prejudice to the claimants, those are matters in my respectful submission where there are very clear findings. I mean, I think you will find in any event the findings I suggest are, save in relation to this question of prejudice to the defendant's limitation defense by reason of relation back, you will find, I hope, that the judge was perfectly entitled to reach the conclusions that she did in relation on the basis of the evidence before her.
In terms of approach, if we were to find that this was not an implied sanction case, and it was therefore an extension of time for allowing the application to be made,
Yes.
She didn't approach it on that basis, so therefore we'd have to exercise the discretion ourselves. And in exercising the discretion ourselves, an appeal court would normally give great weight to factual findings based on the evidence before the judge.
Yes.
And that's the way to approach it, isn't it?
I think that's fair, yes. And indeed, it's perhaps not surprising that my learned friend's appellant's notice did not seek to challenge, other than in relation to prejudice, and in particular prejudice to the defendant. I don't believe that they sought to challenge the judge's other findings.
Can I ask you this? If this is not, if we're persuaded this is not an implied sanctions case,
Yes.
the consequences, we don't have to apply Rule 3.9, which is where the Denton principles come in. So we apply the overriding objective.
Yes.
The overriding objective is to deal with cases justly.
Yes.
What's unjust if we adopt a MasterCard type solution, which you're taking instructions on, but let's assume for the moment that we are in a position to give that undertaking, or we think we can impose it as conditional.
Yes.
What's unjust about allowing you to retain your amendments, but on terms that they don't relate back, and that cures the prejudice?
I would struggle to find any prejudice. I have, which is precisely why I said to the judge at first instance, that may be the easy way to cut the cake, if I can put it that way. I hope I'm being fair in my answer, because it's obvious. It's obvious. That's my answer.
I mean, that doesn't require forming any view of the factual matters that the judge expressed a view on.
Well, I mean, obviously there may still be a question potentially in relation to other factual aspects that bear on the matter, but of course I accept that would be by far the most important consideration, and if one were able to neutralize that in that way, then it's very difficult to see that one would be having any argument about anything. So I see that. And I should add, it is a point that we did also make in our skeleton, albeit by way of footnote, but
Quite a lot in your footnotes.
I'm afraid that's the problem with footnotes. Yes.
That's one of the problems. One of the problems is they tend to be in too small a font to be able to read easily, which is a way of evading the limits on page limits on skeletons.
Yes. There's just one point of principle that I want to make, and then I think I'll just stop here in relation to prejudice, which is this: that and this is the point of prejudice advanced at paragraph 68.2 of the defendant's skeleton argument, which is they said that there would be substantial prejudice to the defendants if an extension of time were refused because they would be precluded, if successful, from relying on a limitation defence to strike out the 1,300 odd claims in the Viegas Claim. If the claims were struck out on the basis that there was an arguable case that the limitation period had expired, the claimants would either have had to seek to lift the stay in relation to the Nicolai claim or receive fresh proceedings. In either event, the defendant's limitation defence would have been stronger in relation to those claims. And the judge essentially disregarded this prejudice. And I just want to be clear that, that our position is, for the reasons given by the judge at paragraphs 129 to 131 of her judgment, contrary to the defendant's submission, even if their ground one were to succeed, in other words, even if the pre-service amendments could be disallowed merely because they have an arguable limitation defence and without reference to prejudice resulting from the operation of relation back, then we say the judge's analysis at paragraph 131 would remain pertinent. And that's because whether or not the defendants succeed on ground one, their pleaded limitation defence, if made good, would be as effective whether or not the pre-service amendments were disallowed. In other words, from the perspective of limitation, which is the stated ground for disallowing the amendments, the defendants are not materially prejudiced as a result of not being permitted to bring their CPR 17.2 challenge long after the expiry of the 14-day limit. But I understand that that argument is really focused on the more extreme of my learned friends' versions of how CPR, how the limitation argument works. My lords, I think I've probably said enough, and unless I can assist you further, those are my submissions.
Thank you very much. Thank you very much, Mr. Cutrale. Mr. Kennedy.
My lords, I am also conscious of the time, and so this reply will be rather briefer, I hope, than one would normally expect after a day and a half of...
No, I have to say, in this court, replies tend to be very brief,
No.
often.
I'm fully aware of that, having appeared before my lords on several occasions where that point was made. So I'll focus on how, on ground one, on how my learned friend responded to my second argument on the application of Rule 17.2. As the court recalls, I had two arguments in relation to the role of prejudice in disallowing amendments to which there is an arguable limitation defence. Just to recap, my primary argument is that when a new claim is added by amendment, which is arguably out of time, it can be assumed that relation back may prejudice the defendant's limitation position, even if he has a general limitation defence. Because, as I said, in general, when limitation is an issue, there is a risk that this prejudice will arise. And because it is an assumption, there is no need to investigate the facts of the particular case. And that explains, I submitted why in Cameron Taylor, Ballinger and Grimsby Cold Stores, although there was a general limitation defence, it was not suggested that relation back gave the claimant no advantage and the amendments were still disallowed. My secondary argument is that when a new claim is added by amendment which is arguably out of time and the defendant has a general limitation defence, the court should assess whether there is a reasonable possibility of the defendant's limitation defence to the amendment being prejudiced by relation back. I refer to my submissions to risk or potential for prejudice. My learned friends' discussion with my lords raised expressions like real possibility or reasonable possibility. We are happy with those formulations. The point is the same. And so the judge will assess whether there is such a reasonable possibility using the pleadings as a whole, as a starting point, and such other material as is before the judge at the hearing of the application to disallow the amendment. For this argument, there is significant common ground. I'm going to make reference to the transcript. I'm not asking the court to look at the transcript now. Is the court receiving a copy of the transcript every day?
I received it electronically this morning. I must confess I didn't open it.
That's quite
I
understandable.
admired it from afar.
I was like a file with hard copy transcripts.
I would prefer. I also got an electronic copy, but I would prefer a hard copy.
We will make sure that you have that, and we'll make sure you have it with the not 4 sheets on a page, which is impossible.
Actually, it is, from my point of view, it's 4 sheets on a
Yes.
page that I like and double-sided.
Okay, well,
Yes.
double 4 sheets on a page, but you're right.
Yeah, I like 4 sheets in it. I
Very
think it's
well.
called
Just make sure-
manuscript.
They're
Make sure
much
you-
easier to carry around. I mean, I obviously, if you have a computer, you can look at the electronic version anywhere. But if you want to look at the hard copy and carry it around, then it's easier to have the 4.
I can see that. Well, we'll make sure that my lords have it, and I'll just give you the references in this reply. I shan't take you to the document itself. But in terms of common ground, my friend Cutrale accepted that in assessing whether there is a real risk of the prejudice, the judge should look to the claimant's pleading and not just the defendant's pleading. That's page 166, yesterday, lines 4 to 6, and page 181, lines 9 to 10. My friend accepted that the court can look at all the material before it and not just the pleadings. Page 177, line 24. And that, of course, is important because the trial judge could find a date of knowledge that neither party has advanced. And this, my own friend, also accepted. Page 169, line 24, page 170, line 2. My own friend also recognised the possibility that the judge would alight for the purposes of knowledge on dates between the two pleaded extremes, and that is a relevant factor. He said at page 170, lines 14 to 21, on this question, there is obviously a whole range of possibilities in between the pleaded dates, some of which you may have been pointed to in my own friend's chronology, because we have picked up some dates to try to be informative to the court as to what this litigation is about. For all we know, if we dug really deep, there would be a whole range of other possibilities we don't know. And that, with respect, is correct, particularly in a case where the claimant's knowledge is crucial, as in this case, and particularly in a case concerning an alleged cartel. As my Lord Justice Lewis commented in the course of argument, in competition law cases, it is common that facts and matters relating to the alleged infringement are concealed or said to be concealed. And the question of what the claimants knew and when they knew it is normally hotly disputed. In this case, as in other competition cases where a limitation is raised, the claimant's evidence, a point I think raised by my Lord Justice Newey, the claimant's evidence and disclosure may be important for resolving whether they had the requisite knowledge before November 2016 or before January 2017. In this case, and on the materials before the judge, it was clear that there was at least a reasonable or real possibility that relation back would prejudice the defendant's limitation defence to the new claims. The period with which we are concerned, although short on its face, September 2016 to January 2017, was, as we can see on the documents, highly significant. The claimant's master particulars of claim places great emphasis on the fact that in November 2016, the defendants entered into cease and desist agreements with the Brazilian Competition Authority, which were publicly announced on the 29th of November and 9th of December 2016. And that is all admitted by the defendants. The claimants plead that as a matter of Brazilian law, a cease and desist agreement with the Brazilian Competition Authority necessarily involves an admission that the defendants have confessed to a breach of Brazilian competition law. That is the claimant's positive pleaded case. The reference is paragraphs 37 and 47 of the particulars of claim in the core bundle, tab 25, pages 394 and 399. And that's important because even if the content of the cease and desist agreement wasn't published, the claimant's case is that as a matter of Brazilian law, one cannot have such a cease and desist agreement without an admission of guilt to the charge of a breach of Brazilian competition law. And it's admitted that the cease and desist agreement, or TCC, was published to the world. And this all happened more than 3 years before the second set of amendments which we seek to have disallowed. And that's for the first set of amendments and the possibility of relevant knowledge being obtained between September and November 2016. Ms. Justice Henshaw's judgment showed that other orange producers, including at least one claimant in these proceedings, had issued claims against Suco Cítrico in Brazil, the defendant's company, in relation to this alleged cartel on various dates from November 2019 to January 2020. I gave you the references in my opening. And that judgment was before the judge in this case. When limitation comes to be resolved, there may well be evidence and disclosure from the claimants, which casts light on what triggered these claims. Because these claims that were issued on and around November 2019 may have been triggered by events in October 2016. And the question is, what, if any, knowledge the claimants obtained over the course of those months in 2016 that may have caused them to begin the process of preparing these claims. Because if a claim is issued in November, the question may be, what knowledge was obtained between September and October 2016? This is not speculation. This is an obvious issue arising on the face of the pleadings themselves, and the claimants' pleadings in particular. And if the claimants' pleading amendments are permitted, if the proposed amendments are allowed, and English law applies in the alternative, a 6-year limitation period may apply. The question then will be whether the claimants obtained the particular knowledge in September to November 2013 that they did not have before. And so when Reverend Friend says, oh, don't worry about the English amendments, they don't make any difference, they may well do, because although the gap between September and December is still a short one in absolute terms, it will be in 2013 the inquiry takes place, not later, where Brazilian law applies. And then that opens a new area of inquiry as to what the claimants knew about the Brazilian official investigations into the cartel following the Dawn Raid in 2006, and the details of the Dawn Raid, the investigations that began then, and the relevant publicity are all pleaded in the particulars of claim, which I've taken you to. One final point on the amendments. My friend said there needs to be a separate inquiry as to whether the amendments cause prejudice. He made that point in argument, but the witness statement, which has been lodged to support the amendment to the pleading, says in terms that because they arise from the same facts, they pass through Rule 17.4 without any need to look at limitation. I won't take you to it. It's Evans 26, paragraph 33. It's the witness statement that we exhibited to the Land of Marshall application. Now, this demonstrates two things in my submission. First, that the judge's approach to examining the defendant's pleaded case only was wrong. And that's paragraph 82 of the judgment. I shan't take you to it. My lords have it very clearly in mind. The judge was absolutely clear that in order to assess the question of prejudice, one looked only at the defendant's pleaded case. And she said in terms that the claimant's pleaded case was irrelevant. Still less was it appropriate to look at the other material before her. That's paragraph 82 in the core bundle, page 224. The second point is that on the parties' pleadings and the materials before the learned judge, that prejudice to the defendant's limitation defence to the new claims was, as I said, at the very least, a reasonable possibility. And the threshold should be set no higher than reasonable possibility. As Lord Justice Tomlinson said in Ballinger, paragraph 27, in these applications, the claimant is asking the court to make a summary determination that the defence of limitation is unavailable for these new claims. And just to recall what he said that in circumstances where there was a general limitation defence. So in principle, a test of reasonable possibility of prejudice, looking at all the materials, is the appropriate test. The claimants are always able to protect themselves by issuing protective proceedings, which they could easily have done here. And we say it would have been obvious in late 2019 or early 2020 that they should do so when the defendant's company was issuing strikeout applications in Brazil based on the 3-year limitation period. Moving on to ground 2 of our appeal and the question of relief from sanctions. My own friend's primary focus was on the fact that it was effectively to the effect that because no possibility of accommodating a jurisdiction application is contemplated on the face of Rule 17.2, our argument that there should be an implicit 14-day period conflicted with the purpose and terms of the rule. That is nothing to the point. The rule itself would not be expected to, on its face, accommodate the jurisdiction application. If that were the case, we wouldn't have to have the implication, we wouldn't have had to argue for it in the way we have done. The real question is there a genuine risk, or was there a risk of submission? Now, my own friend outlined what he said were the routes to avoid submitting to jurisdiction, which he said were obvious and safe. They were not obvious to the judge in the Newland case or the Court of Appeal in Global Multimedia or to the authors of the textbooks. And the word safe is an important word because in none of the authorities, save perhaps for that of the Chancellor in the Zhivago case, are these routes described as safe, providing claimants with security. What my own friend described was, in his own words, a trend, a clear trend in the modern authorities. And there may well be such a trend, but there is a large gap in my submission between a clear trend in the modern authorities and an approach which is safe and secure for a litigant, not least because of the drastic consequences of inadvertently submitting to jurisdiction. The only safe way is to deal with jurisdiction first and issue the application afterwards. My own friend said that the approach which we contend is contrary to clarity and certainty. On the contrary, if clarity and certainty are important, it is not appropriate to force litigants to take the risk of submitting to jurisdiction by making applications for extensions of time for a Rule 17.22 application, to take that risk and deal with the drastic consequences. That generates confusion and cost and waste and potentially adverse consequences. It is much.
Do you say that it would have been unsafe for you to write a letter saying we are actively considering challenging jurisdiction? We notice that you have amended pre-service under Rule 17.1, which gives us a right to apply under 17.2 if we engage with the merits at all. We are not at this stage engaging with the merits, but we put you on notice. If our application for jurisdiction fails, we will at that stage consider whether to engage with the merits and apply under 17.2, and will, of course, at that stage apply for an appropriate extension of time. Do you say that would have been unsafe?
Potentially, yes, my lord. Because on a bad day, could it be said that although it's hedged around with caveats, is that not in truth a threat? Is that not, does that...
It's a very conditional strand. it's not unless you do something, we will do something. It's, if our jurisdiction challenge fails, we'll then think about it, but we want you to know we will then think about it.
The purpose of that letter would be to put them on notice,
Yes.
and that would be.
You say that that could be construed as abandoning the jurisdiction objection, which I think is the test.
Sorry, I just want to understand, my lord, there are two different points. One is, could such a letter be itself a submission?
Yes.
And the second is, what is the vice of not sending the letter a failure to give them notice so that they could issue protective proceedings?
Well, at the moment, the question I'm asking you is are you saying that could be construed as a submission?
It would be difficult. It would be very difficult to say that would be a submission. I entirely see that. The letter alone, caveated in that way, would probably not be a submission. But if the failure to send the letter is they weren't properly warned and prejudiced as a result, you have my submission. They suffered no prejudice because everyone knew, and they knew especially, that the defendants would take limitation points at every available opportunity.
There is a sort of irony here, going off on a red herring for one moment. I mean, suppose you hadn't been making a jurisdiction challenge. It really wouldn't have been worth you making a 17.2 application. I mean, what would have been the point? They'd just have issued protective proceedings and you'd have gained nothing.
I have not considered that, my lord. But
Is there any evidence anywhere as to why you did take the approach you did?
no, not unless I'm told. Sorry, my lord, I'll just check that. I mean, so there's no evidence directly on the point that you put to me, but just to get back to reality for a minute, we did write them on the 7th of June 2021. You
By
have my
then,
point.
there was something at stake.
Sure, but the point is...
There wasn't originally.
No, indeed. But the question is, if we're looking at whether they're prejudiced and whether a warning made any difference, even then, they waited until November 2022 to issue protective proceedings. We wrote to them on the 7th of June 2021. You have my submission that they knew from November 2019 that the jurisdiction was going to be, limitation was going to be an issue. But we wrote to them on the 7th of June 2021. They waited until November 2022 to issue protective proceedings. So this debate about warnings and prejudice, it's just unreal. And this is in circumstances where it's a highly resourced team, properly funded, expert counsel, solicitors, and whatever the resources are required to run a piece of very substantial competition damage litigation.
Can you just remember the date that you actually applied made your jurisdiction application?
I have to find that in the chronology.
Okay, don't worry.
Sorry,
Don't worry now.
somebody will hand me a post-it. I haven't
I
got
will tell you.
5th of June 2020, but it'll be checked. But my short point on the question of principle, because we're just dealing now with the question of reading in a 14-day extension, so I have to do with the question of principle, is that in the absence of an implicit extension of the type for which we contend, the defendant is forced to take the risk of submission or not exercise or vindicate his rights under Rule 17.2 and focus on his jurisdiction application. And my own friend didn't shy away from that. He said, the implication may well be that the defendant is forced to choose. And he said, well, they could bring a strikeout application. They have to forego their 17.2 application, but they could bring a strikeout application. And he said, and when he was asked, will that be on the same basis? He said, not exactly on the same basis. Well, very much not exactly on the same basis, because when pressed, he had to acknowledge that instead of being able to rely on an arguable limitation defence, we'll be forced to show that our limitation case was unanswerable. There is a very substantial difference. And forcing a defendant to forego his rights under 17.2 would be unjust. That would be forcing him to forego something for which he may be entitled to raise a legitimate point in order to save and not threaten his jurisdiction application, which is also a point he can legitimately take.
In your skeleton, have you got the form of words that you say needs to be implied into 17.2? Because this is a rule of court.
Yes.
And, you know, one has to have clear what the scope of the implied extension is if it's going to be service of a copy of the main certificate case on them, brackets, or something else.
Although we haven't separated in a separate passage, it is very close to the wording that would be inserted. But we will get that for you. So you have a particular language that would have to be inserted.
Yeah.
But it is in the skeleton, my lord. And
Right, I think I've seen it somewhere.
Yeah. But again, conscious of time,
Yes.
I'll provide that to you, but I will move on. And we're still in, now we're an implied sanction. Is there an implied sanction here? And my friend ran straight into the authority that I took you to in Yes and in Lufthansa. And his position remained that any breach of an order which says a thing must be done by a date and by implication cannot be done without an extension requires relief from sanctions. And that is the opposite of what this court said in the Yes judgment following Lufthansa. And it wasn't an accident that Lord Justice Burst took the position that he took. He found, and it was part of the ratio of the case, that there needs to be a very strict and limited approach to the categories of implied sanctions. He did not say that the categories were absolutely closed for all time, which is why I did not make that submission. One must read paragraph 31 with paragraph 33, but a very limited and strict approach has to be taken. And it has to be taken for the reasons he gave in paragraph 31, which is that it is unnecessary and inappropriate to adopt a more generous approach to this concept of implied sanctions. It is unnecessary and inappropriate for the reasons he gives in paragraph 31. And there is a difference, a relevant difference here between notices of appeal and respondent notices and applications under Rule 17.22 for the reasons put to my own friend by my Lord Justice Lewis. And I should say no more about it, and I'll move on now to how you approach the overriding objective if that is the proper approach. My own friend said that your hands are tied in relation to examining questions of fact addressed by the judge below. That is also wrong. If you were with me so far, you would have found that the judge made an error of law in applying the Denton criteria. That means the judge would have looked at the facts through the wrong lens. This court is entitled to look at the same facts through the correct lens. And the correct lens is the overriding objective and what is just. And for those reasons, you are entitled to take a different view from that taken by the judge in looking at the facts the judge considered. My lords, unless I can have any further assistance, I think that's all I should say by way of reply. I won't take any more time.
Thank you very much. I don't detect any more questions. So, Mr. Cutrale, we're back to you, aren't we?
May I deal therefore with ground one of the claimant's appeal? That ground concerns 12 claims which were originally brought in the names of deceased persons, but which were amended pre-service under 17.1 so as to substitute a deceased person with a living claimant. And the judge accepted that those living claimants are entitled to pursue claims in respect of their own personal losses, but this is subject to the defendant's separate challenge under that ground 3, which we'll address later. But the judge also ruled that insofar as those 12 claimants are claiming in respect of the losses of deceased persons, they could not do so because the original claims in the names of the deceased persons were nullities, and there was therefore nothing to be substituted. And again, just by way of introduction, so that I can show you the form of the amendment, and I think it's usefully set out in the defendant's skeleton. That's in relation to the claimant's appeal at page 145. We'll see more examples of that kind a little later, but probably we can do it. One, paragraph 16.
So I missed the references entirely. Which bundle and which page are you taking?
So sorry, this is core bundle, tab 13, the defendants' skeletons.
Oh, right.
Yes, I'm sorry, I kind of assumed you might have that as a separate document. So it's paragraph 16 of the defendant's skeleton in the claimants account, 35 page skeleton. So look at paragraph 16, you'll see, hopefully you've got a color version of it.
Yes.
And that, and so if you look at the text with the red and the green, the original claimant was Mr. Sergio Cesar Stamoto, who was in fact deceased at the time when the claim was commenced. And there was then an amendment, or perhaps two amendments, over the period November and January, whereby that was changed to the estate of.
You said it was changed, you put it in the passive. Which party made the change?
The claimant made the change.
You said.
Well, those acting on behalf of effectively Elizabeth de facto Stamato, who is now the claimant, albeit expressed to be as a representative of the deceased person. So that's the change that was made, and so there are effectively two issues that therefore arise out of that form of amendment, and I just want to show you what it is first, so that we understand what the issues are, and the nullity argument is not the only obstacle that's faced by those 12 claimants, in the sense that even if their pre-service substitution by a living claimant were permissible, despite the nullity principle, the living claimant still has to meet the defendant's argument accepted by the judge that they could not pursue their claims in respect to the losses of deceased persons without having obtained a prior grant of letters of representation. So there are two obstacles for those particular claimants to overcome.
Okay, can I just be sure? You first amended by changing Sergio Cesar Stamato to the estate of Sergio Cesar Stamato. Is there any provision in the rules which allows a claim to be brought in such a form, the estate of X? There's clearly provision which allows claims to be brought against the estate of X, because a claimant can't force a defendant to appoint a representative, so you can bring a claim against the estate. But is there any rule which allows you to bring a claim in the name, in the estate of X? The estate of X?
If there is, I'm not aware of it.
No, I'm not aware of one either.
No,
So what we're really concerned with is the Green Amendment.
yes, which is no doubt why.
Aims at an individual. Yes, thank you.
Again, I wasn't party to this process, but I mean, I infer that there was a first inchoate amendment, if I can put it that way, that was then completed by the addition of the Green. But the point is that those 12 individuals who are expressed to be suing as representatives of the relevant estates of the deceased persons, they face two difficulties. The first is the deceased person forms nullity argument, and the second is the absence of letters of representation.
Yes.
Ground one is only concerned with the nullity point, not the grant point. So I just want to deal with that first. And again, just by way of explanation, I appreciate I may be saying things that you're already aware, but certainly when I first got involved in the case, there's a lot of detail about how all those cohorts are made up, which is quite intricate. But so just to be clear, those 12 claimants themselves form part of a larger group of 105 claimants who have all brought claims expressly as representatives of an estate. and that gives rise to, or the larger group, the existence of that larger group gives rise to a number of interrelated issues that obviously will arise and that I'll address in the context of grounds 2 and 3. But coming back to ground 1, so far as the nullity principle is concerned, the law is adequately set out in the judge's judgment, including relevant passages of Timothy and Yogi and Seeley. We can perhaps briefly look at the judgment. Core bundle, tab 15. In fact, perhaps we can just have the page open for the moment. I'll come back to that in a moment. I'll just carry on with my general overview of the position. So the judge basically in those paragraphs, 144 to 148, that's page 235 onwards, set out the scope of the nullity principle. And effectively what is an issue under ground 1 is whether the nullity principle is broad enough to prevent a pre-service substitution of a living claimant for a deceased claimant under CPR 17.1. That's the issue. In the context of ground 1, if we ignore the grants point. And it's necessary, therefore, we say, to start by identifying the proper scope of the nullity principle. And there are, in fact, 2 separate, though related, strands to the nullity principle. The first strand is the principle that a claim cannot be brought in the name of a deceased person. And this is the strand that is identified at paragraph 144 of the judgment, quoting from paragraph 5 of Mr. Justice Stewart's judgment in Timothy. So if you look at the bottom of page 235, the judge introduces Timothy, and then at the top of page 236, the first principle is that a claim cannot be brought in the name of a deceased person. And there's a long-standing authority for that proposition. And at the bottom of, at the end of that quotation, it is well established that proceedings are only a nullity if the plaintiff is dead or non-existent in the sense of being a body corporate that has been dissolved at the time when the proceedings are commenced. So it's a form of nullity that essentially turns on the non-existence, in fact and in law, of the claimant.
That statement must be an overstatement, that they're only a nullity in those circumstances.
Yes,
If you issued a claim in the name of Sherlock Holmes, that would be a nullity.
I think probably in the context in which that sentence was uttered, it made sense, but I entirely accept that, and I don't think the judge read it in that way, but yes. The second strand is that an action commenced by a living claimant, purportedly as representative of a deceased person, is a nullity when the claimant was not in fact duly constituted a representative of the deceased person's estate under the applicable legal rules. So that's not a case of a claim by a dead person. It's a claim by a living person who claims to have a certain capacity that is essential to the claim, but does not in fact have that capacity. And that is the strand that also engages nullity. And it is the strand that was reviewed in detail by the Privy Council in Yogi and Seeley, and is quoted in paragraph 148 of the judge's judgment. The judge helpfully underlines some of the key passages in the extract from Yogi and Seeley. And I don't think that I need to take you to that in detail at the moment. Again, I'm really scene setting for the particular issue that arises in relation to ground 1. So
does that issue apply to ground 1?
The second strand. No, well, that's precisely my point. That
I mean, it seems to me to be a quite different principle. The principle that you can't issue in the name of a dead person is
Yes.
simply you don't have a client, you don't have anybody.
There's no one. There's no
nobody.
claimant.
There's nobody.
Yes.
Which is why I say a fictitious person is another example of the same thing.
Yes.
Whereas in the latter case, all you've got is a client who's misunderstood what their legal rights are, and it seems to me to be a quite different type of case.
Yes. But they're often mixed up, if I can put it that way, in the sense that they're both situations where the authorities have treated the commencement of the action as being a nullity, and therefore being, as it were, incurable.
Well, I understand that that's what the authorities say, but they do seem to me to be very different types of case. But ground one is concerned with the first type of case.
Exactly.
You don't actually have a client at all.
Correct. Exactly. Again, I think we're at one. I'm simply setting the scene so that we understand what is at stake in relation to ground one. And so, and again, just by way of background, it's in the context of the second strand, in particular, that the issue has repeatedly arisen whether the nullity was curable if the purported representative succeeded in obtaining a grant of representation after the claim was commenced, and whether it could rely on the subsequently acquired capacity to continue the claim. And the case law repeatedly said, no, too bad. It's a nullity to start with.
The rules have been changed to allow that.
Rules have been changed in CPR 17.44, but only where limitation has expired. The rationale being that if limitation has not expired, well, you can start again. So we'll come to that in due course, because that introduces some interesting issues as well. So in the context of the second strand, the courts have consistently said that since the original claim was a nullity, because the claimant did not have the necessary legal capacity when he or she brought the action, subsequent acquisition of a grant of representation can't cure the original nullity. And as I was saying, under the second strand, it's important to note that the issue is not one of substitution of a deceased claimant by a living claimant. The claimant who claims to have the relevant capacity is the same living claimant throughout. It's simply that there's a subsequent acquisition of proper capacity. Now, ground one, as we've said, is concerned with the first, not the second strand of the nullity principle. And in particular, ground one raises the question whether a claim that has been commenced in the name of a deceased person can be substituted by the claim of a living claimant. There's no specific authority that either party is aware of on this point. It directly addresses...
A claim isn't commenced in the sense of it happens like a volcano erupting. A person brings a claim. And there isn't, sadly, a person here in these 12 cases because they've died.
Yes.
And if they've died, they can't change their claim, can they? So somebody else is said to be bringing it.
Well, in short, the argument is this, and I'm still developing it, but the short point is this, that the divisional court in Rowett made very clear that you can add a claimant.
Existing claimants could add. If you read Rowett carefully, for all these people suing about the Mercedes-Benz emissions or something, and they say at one stage, it can be treated as if the existing claimants could add. There were lots of claimants there who were upset about their Volkswagens. But it doesn't seem to say where dead people have their names taken by solicitors and put into claim forms that they can substitute. You've got to read Rowett carefully. I'm not sure that it says what you say it says.
Rowett doesn't address specifically the situation of dead people and deceased people, and I'm not suggesting that it does. But what the more generic point that I'm making is a new claimant can be added to a claim form pre-service, right? And so the question, and of course, a deceased person who shouldn't have been a claimant can be removed as a claimant. I don't think anybody would suggest that that can't happen. And so what happens when there is a substitution of a deceased person by a living claimant, in my respective submission, is effectively what is happening is the amendment consists of the removal of the deceased person as claimant and its substitution or replacement by the living claimant as the claimant.
But in another sense, in this scenario, you are giving life to something that had no life at all before.
Well,
And your the particular points you're making don't really deal with that at all. I mean, if you've got a claim form that has life, fine, you can add another claimant. If you've got a claim form that has life anyway, well, you can take out a deceased claimant.
yes.
But this is different. This is a question of bringing to life something that had none.
Well, it's not different in the sense that the claim form in this case is not a nullity.
Well, I was going to ask that.
The
Does
claim
it make
form-
does it make a difference that you've got hundreds of claimants who are perfectly alive and well?
But they're different claims. I
And
thought.
have issued a claim form. So you
Yes.
can't say the bit of paper is a nullity.
No.
That bit of paper operates to start proceedings on behalf of all living claimants who are named in it.
Absolutely.
And that might be a different case from where you only have one dead claimant, where you can properly say this bit of paper, although it's purported to be a claim form issued on behalf of X, it's not a claim form issued on behalf of X because X doesn't exist. It's not a claim form issued on behalf of anybody else, obviously.
Yeah.
What it is an act by the solicitors without authority, purporting to have authority to act for somebody and not having any authority. And
Yeah.
the solicitors can become personally liable for any costs incurred as a result. But you can see very easily why, if you issue a writ, a claim form in the name of Sherlock Holmes, it has no effect at all. There's nothing for you to amend. But that may not be the same if you've got a claim form which is a perfectly valid piece of paper for the living claimants, but just has some dead claimants added in as well.
Yeah. Well, that is certainly one of my points, and I will come on to that in a moment, if I may. But it is a feature of all of the cases, the historic case law, if I can put it that way, that has repeatedly enforced that rule and treated the claim as a nullity. They are all situations where there's a single claimant, essentially.
But I thought the difference between the claim and the claim form, I thought the rule said, but you'll know it much better, that you can combine a number of claims within one claim form. So the claim form is the document that records the separate claim. There may be 100 claimants and 100 claims, but they're all separate. So if they're separate, although I hear what my law says, if they're separate and there's one claim brought by person A, and in fact that person is dead, there is no claim. There may be a claim form which may purport to record the fact that somebody who didn't have a claim because he was dead has brought it. But that claim doesn't exist as a matter of law because the law doesn't recognise it. So the claim form and the claims are different, aren't they?
Yes.
And one is a record of the other.
Yes, absolutely. But what appears, just so that there's no confusion, we have never, by the amendments, sought to preserve the claim of the deceased claimants.
So
The purpose of the substitution is to replace them by what we say is the correct claimant, subject to the grants point, leaving that to one side for the moment. It would be no different. Take this example where effectively Mr. Stamato's name appeared in one row of the claim form. The amendment could be done in a number of ways. One way in which it could be done is we cross out Mr. Stamato's name, and his daughter, who claims to be entitled to sue in his right or as representative of his estate, could be added in a separate row of the claim form. There could be no objection to that.
So just talking around that a moment. So suppose Mr. Stamato had never been in this case at all before,
Exactly.
and then pre-service, you want to add in a claim by his daughter
Yes.
in respect of Mr. Stomato's claim,
Yes.
you say, well,
There's nothing to
that's
stop that
different
happening.
because you've got an existing claim form with claimants who exist.
Yes.
And then it really doesn't matter whether you take out Mr. Stomato or not, because
No, because it's
or
a
you-
nullity anyway. I
Well,
mean,
you could have done
law-
it in two stages. On day one, you could have struck out Mr. Stomato's name,
Yes.
recognising that he's dead.
Yes.
And on day two, you could have added his daughter's name.
Yes, and we might have added that he's the daughter of Mr. Stomato, but that would have been purely part of the description of the new claimant rather than the addition of the deceased name as a distinct claimant. And so the judge, to be fair, recognised the absurdity, or as she put it, the triumph of form over substance in a case such as the present. Not, of course, in a single claimant case where you can say the proceedings are a nothing from the outset, but in a context such as this, she understood that point, and that is why I think she said what she said in 147, and indeed why she gave us permission in relation to this ground. But we do say that this is a point of principle in a way, and it's very difficult to see as a matter of principle why this kind of amendment can't be made, where you're removing the deceased person as the claimant, and you're substituting or adding a new claimant.
I think adding is a better description. I prefer adding. Because
Adding,
what
yes.
you're saying is, I'm a new person, I'm suing in this capacity. And you could leave the name of the deceased there or not, but that claim isn't a good one
Yes.
because they didn't have a claim. But what
Yes.
you're saying is they're not substituting or changing that claim, which was an inept claim from the start,
Yes.
really, but they are simply bringing their own claim, and they're doing it conveniently by avoiding retyping the words Stomato.
Yes, exactly. And I agree with you, maybe that we have somewhat misused the term replace, substitute, and so on, and that the more accurate term to recognise the nullity, as it were, would be to say it's a case of an addition of a claimant
Claim by a new person, but
By a
there's
new
nothing wrong with
person
that pre-service.
who may happen to have some familial relationship with the deceased, but which is neither here nor there for present purposes. There is an interesting aspect of the decision of Mr. Justice Stewart on this point. If I can explain that briefly. So if we look at Kimothy at tab 35, if we look at, and this is an interesting case because it's a group action where a dead claimant was added to the group register, but where clearly the action had a life of its own and wasn't a complete nullity by dint of that fact. So if I can ask you to look, pick it up at paragraphs 1 and 2 for the basic facts. I won't read it out, it's probably quicker if you read it yourselves. And then if you go to paragraph 4, you will see the defendant's contention, bottom of page 877. And then if you go to, we've seen paragraph 5 already over the page, the statement of the first strand of the nullity principle. But the second strand was also potentially engaged in that case, which is why you see the reference to Ingol and Moran at paragraph 6. And then at paragraph 8, in short, the defendant's submission is, because TC11's name was added to the group register on the 14th of March, 2014, and he had died on the 23rd of August 2013. The claim was brought when he was already dead and was, on the basis of the authorities cited, a nullity. The claim was brought in TC11's name and not that of his estate. And then this, even if the claim had been brought on behalf of TC11's estate, when his name was added to the group register on 14th March 2014, no valid estate claim could have been brought, as the grant of administration in Kenya was made on the 28th of January 2015 and was resealed in England on the 22nd of March 2016. And then if we go to paragraph 16, in summary, on the first issue between the parties, in my judgment, the position is as follows. The established law, according to the first principle set out in paragraph 5 above, is that a claim cannot be brought in the name of a deceased person. The claimants accept that, notwithstanding the individual particulars of claim and the individual reply. The claimant's name was added to the group register in his personal capacity and not in the capacity of personal representatives acting on behalf of the estate. And there's a reference to footnote 2, and footnote 2 you will see on page 884. And the judge has footnoted, even if it had been, in other words, even if the personal representatives had claimed on behalf of the estate, the second principle set out in paragraph 6 above applies. The second principle being the principle in Ingle and Moran. And so what is interesting about this observation by the judge, in my respectful submission, is that he did not suggest that an amendment to replace the deceased person as claimant with the personal representatives of his estate would be precluded by the first strand of the nullity principle. Rather, he suggested that an amendment would fall foul of the second strand, insofar as, on the facts before him, the grant of administration had post-dated the addition of the deceased claimant's name to the group register. And so, whilst of course I accept he does not address the point explicitly or in detail, certainly his approach in that case implies, or at the very least leaves open the possibility that the first principle that he referred to in paragraph 5 would not itself have precluded that form of amendment. I think I can summarize my submissions briefly on ground 1 as follows, and I think I can probably do that in 2 minutes.
Go ahead.
Break if that's
Yes.
the court. First is the point I've already made: the pre-service addition of claimants is entirely permissible. See Rowett and Daimler. Second, in the light of that decision, the judge rightly accepted that the removal, addition, and substitution of claimants generally take place prior to service of the claim form. See paragraphs 147 and 149 of the judgment. However, she took the view that the claimants cannot be substituted, or for that matter, be added under CPR 17.1, quote, if the original claimant was deceased. That, we say, with respect, is a narrowing of the scope of CPR 17.1 that's not justified as a matter of principle or common sense. We've already been through the practical examples that illustrate why that would not make sense. And the absurdity of that approach is further illustrated by the example that we give in footnote 16 of our skeleton argument. Which I think is...
We're back to the word substituting.
Yes. I think adding is better for the reason that Lord Justice Lewis gave.
And 17.1 allows both adding and substituting.
Indeed.
So if the judge had in mind merely substitution,
yes,
maybe that was erroneous.
Yes, yes. And one can see how the concept of substitution is more difficult to fathom, as it were, if if there was nothing there in the first place.
Well,
or-
firstly, if it was nothing there, and secondly, if it was somebody else's nothing.
Yeah.
It's one thing to bring your own claim, it's quite another to say, I rather fancy yours, I'm going to take it over.
Yes. Yes, but that may be the short answer, and it's a linguistic point. But the addition element is the key element, of course, and that in my respectful submission can't really be objected to as a matter of principle. And neither Kimothy nor Yogi and Seeley compel the conclusion that the judge came to. And if anything, as I've just shown you, Timothy suggests that would be perfectly possible, subject to the grants point.
Is that a convenient moment?
I think it is, and I'll finish ground.
2 o'clock then.
Rise at table.